Well, good evening, and welcome everyone. I want to thank you so much for joining me this Saturday evening. From the UK, from the United Kingdom, from the, the I don't know why they call it the motherland. The motherland is actually Africa. They call the UK the motherland, but from what is happening with the whole massive debate and discussions talking about dual citizenship diaspora conference. Well, we are here right now from the UK, and I want to thank those who are joining me on YouTube, those who are joining me on Instagram, those who are joining me on Facebook, and of course the overflow on TikTok. Welcome and thank you so much for joining. Of course, you can watch and you can listen, but in order to see the full shebang, you'll have to go over onto the YouTube channel and you can give your comments. Of course, your comments are always welcome at the same time, and I do incorporate a lot of the comments as well. In Jamaica at present, there's a lot of discussions which are going on now in regards to the constitution reform. Constitution reform is a big thing, and it's an exciting time, I would say, for Jamaica. It's an exciting time whereby in 1962, many Jamaicans weren't able to really take and be a part of the whole process, and somewhat being very excited, should I say excited, or being able to be a part of the whole process, having these different discussions, having these different town hall meetings, and even now we're having whereby the commission has now put forth a recommendation to Parliament. I believe and I understood that maybe it has been tabled already, and now we've got a big issue regarding the dual citizenship. Some are saying bring that into the recommendation as well. But the most important thing, that it is an exciting time for Jamaica, an exciting time whereby we want to move away from semi-independence. What should I say? Semi-independent. Some say we're independent, some say we're semi-independent, or whatever like that, because I believe in 1962, that was the process of the start of full independence. And now we're on the threshold of becoming a republic, where we remove the King of England as our head of state, and therefore we become one. Of course, the recommendation is talking about a non-executive president. Some are saying it should be an executive president. Some are saying there should be a Caribbean Court of Justice instead of a the Privy Council as well. But that's something else. But before I go any further, I just want to say that I'm drinking just some wine tonight. Talk and sip. You can tell me, ladies and gentlemen, what you're drinking. Just a small wine. Just enough going to church in the morning. So enough like a Lord's Supper. You know what I'm saying? And some water as well. And so tell me what you're drinking. Just your comments and tell me what you're drinking tonight. It's a very serious night, and I have tonight as my guest Mr. Christopher P. Malcolm. And Dr. Malcolm is a senior lecturer and deputy dean, graduate studies and research at the Faculty of Law at Mona, University of the West Indies, Secretary General, Jamaica International Arbitration Center Limited, Fellow Chartered Institute of Arbitrators, Vice Chair and Fellow Asian Institute of Alternative Dispute Resolution, and a certified international ADR practitioner. He is a former Attorney General, British Virgin Islands, former head, legal unit, Organization of Eastern Caribbean States, and founding member and past chair of the Chartered Institute of Arbitrators, Caribbean. Dr. Malcolm has been admitted to practice law in Jamaica, the British Virgin Islands, Dominica, St. Lucia, Belize, Barbados, and Trinidad and Tobago. And his practitioner and academic interests include banking and financial law, regional integration and economic development, arbitration and ADR, corporate and commercial, including construction and insolvency. I'm going to bring in Mr. Malcolm right now to have this discussion, and looking forward for your interest as well and your involvement. Thank you very much. Good evening, Sir Malcolm. How are you doing, sir?
Good evening to you and to your morning, afternoon, whatever it may be, to you and your guests, wherever they may be.
Yes.
I'm not drinking wine. I'm drinking a well-strung roots blend.
You're drinking the roots blend. Well, cheers, sir.
Cheers to you.
Yeah. always say that I on a Saturday night before I go to church, I always say I drink enough as if it's a Lord's Supper portion. In case my pastor is watching, you know. Um, but listen, I want to thank you so much for joining, and all the way from Jamaica, and later on I'll be having a couple of other guests. They'll be coming on from the UK, USA, and also Jamaica as well. Sir Malcolm, Jamaica is at a very crucial point. I think we're at a threshold of something exciting about to happen in Jamaica. And I want today for you to sort of share your views along the line with different areas in this whole chapter. You know, we are talking about the CRC making recommendation for a new updated constitution. We're talking about the public education. The topic, of course, is the people. Put it to the people. You know, dual citizenship. You know, the recall process of MPs, and what does the CRC representatives say? You know, and should we be so much involved in it? So, and also one important thing, the diaspora. What are your thoughts on the diaspora as well? Sorry, I'm throwing a lot at you tonight. You know,
It,
but first of all, tell me, yeah, you go for it, sir. Yeah.
it is in fact a mouthful, but one of the things I'm happy to see, quite frankly, about your topic, put it to the people. It
Yes.
resonates with me for this reason.
Yes.
When I did work in the area as a student and also in practice,
Mm.
in the area of law reform and policy development, in support of law reform, one of the things I learned, which has stayed with me, is the need to work with a grassroots up approach,
Yes, sir.
which is where the people are. And you find as well that once you take it in that way of working from the grassroots or working with or through the grassroots, then you are likely to get better support. One, you're likely to hear the voices of the people more, and you're likely to get less of an approach of persons being dictated to and feeling uncomfortable in their own skin, in their own environment, because they have not critically been involved in the process that surrounds them. So,
Yes.
as we get to the process of constitutional reform and the process to be engaged,
Mm.
it is clear in my own mind that unless and until the people are completely and fully involved to the maximum extent possible,
Yes.
then anything coming out of it must necessarily be defective. That's a point I think we could all agree on.
Yes.
And it is for that reason, including as well, and then I go back to the fact that I am an educator, among other things. And one of the things as an educator we are interested in is ensuring that you educate, not just by reference to trying to pass on grand theoretical views about things and so on, but in a manner that will resonate with people and will have people feeling as though what you're saying is coming from them, is a part of them, and something that they feel inclined to support.
Yes.
Sadly, in many instances, we have seen change, not just here in the Caribbean, and when I'm saying the broader Caribbean, not just Jamaica, but in the UK and elsewhere as well, where very often change happens and the people are not sufficiently engaged in it. And then you see the disaffection coming through, and you see all the other maladies coming out of that process. And it comes out of it very often because the people do not understand. There's also another thing, and I know you're a lawyer, as I am.
Yeah.
And one of the
Mm.
things we learn early enough in law, everybody knows it whether you're a lawyer or not, is, this grand thing, and I harp back to it so often, about ignorance of the law being no excuses.
No excuse. Yes.
And we
Yes.
say
Yes.
it, and we send people to jail on that basis. We do all sorts of things by reference to it. And it saddens me very often to hear us saying that when, as the state, we often do not put efficient and effective processes in place for people to get to know the law. We keep people in ignorance. And that
Mm.
is why, even outside of this, outside of my regular teaching, one of the areas I have been involved in, not just in Jamaica, but beyond, is the area of street law, where we aim to, as we say, demystify the law and take it from the cathedral to the streets, so we can get people more involved, more aware of what is happening, and to get the law in a manner which really gets to the brass tacks without all the grand theoretical underpinnings and so on that are there. So people can understand it, they can be part of it. And the truth is that the law can be made simple. The truth as well is that the law can be made understandable. But unfortunately, there are many of us who like to keep it all in the cathedrals, and we restrict those who have access to the cathedrals. And I think the processes that we engage, including a constitutional reform process, must be premised on moving away from the cathedralization of processes to the streetification, and those are my words, of processes, so that people can become a part of and feel that they are represented, and effectively so, in the societies where they live.
Do you think that, for argument's sake, in Jamaica, based on what you just said, that people are somewhat sensitized as to the whole process of which is happening? I was in Jamaica recently, and I went, and I use this as a classic example. I've been to my previous primary school. I went to my previous high school. I went to my previous coming to college just to say hi. And one of the things I was thinking about is saying, wow, these institutions should be able to have some classes like every month or every 2 weeks for the community, where you got maybe law practitioners or students can actually come down and actually break it down to the community, not to the children or so, but to the community, as to this whole exciting period of constitution reform. Instead of waiting just for the town hall meetings, which are very limited. And of course, as someone put it out a while ago, does Dr. Malcolm think the public has been turned off because the deliberations were not live cast? You know what I'm trying to say?
Tell you something, and I'm happy to hear you speaking, and I'd like that someone, yourself and all others, to support programs that we've been doing along that line. One of the things I've been fighting, literally fighting and working hard, try to have adopted here in Jamaica in a structured way, is a viable street law in schools initiative. And the whole idea for that is to have street law, or the law program related to the law, the taking it from the cathedral to the streets approach, implemented as a curriculum course in all of our schools. We have tried to get it here, it hasn't happened yet, but I can say I have it going on and going on well. For example, in Belize, and we have a very well established program happening in Belize as we speak that I have had implemented there, because it was easier to get it done, quite frankly. And one of the things you need for these things is to have them properly supported. And one of the things we do in that program is to get students from as early as we can get them in a very well-structured program, which is taught as any other curriculum course, not because you're trying to make people into lawyers, but because you want them to become more aware of it. And one of the critical areas of that is the area of citizenship and governance related to the Constitution, how it functions, how people can better better function as citizens, and how to better relate to governance and their understanding of it. And in that process, if we get it right, then it will do exactly what you're saying. In substance, it is civics on steroids. That's what we do. And so what you're asking about is something which can be there. It is available. And there are persons who are prepared to give up their time and effort to make it happen. I do all of what I do, for example, in Belize and in other places too. And it's all pro bono on my part. But it needs to have some support around it for it to happen. And the idea is to get persons not to become aware of their legal rights. And what we've found is that when people become more aware of their legal rights, one, and the evidence is there to support it. And street law is an initiative, just for the record, for those who may not be aware. It started as an initiative at Georgetown University in the US in 1972. Professor Ed O'Brien. And it has spread across in many countries. I brought it to the Caribbean via South Africa, where it has done exceptionally well to take people from the apartheid era into a better understanding of legal rights and so on, into the new era, right? And one of the things that you learn in doing these programs is that you've found, and the evidence is there to support it, that in schools where persons become more aware, and in communities as well, because it's not restricted to schools, where persons are more aware of their legal rights, you find it having positive implications for crime and violence, as in there's a lowering of that. People are taught how better to manage their conflicts.
Yes.
People are taught how better to manage themselves away from simply becoming employees to becoming entrepreneurs and employers, and to how they're better able to manage their contractual relations and all the other things that we know are critical. And the starting point, of course, is to say that at the core of every single thing that we do, including whether you breathe fresh air or not, is a legal arrangement or is a law that determines what you may or may not do, whether or not you go to church tomorrow. Is a question of the society you're in being where it is permitted so to do. The laws could be passed preventing you from going to church tomorrow. We just spoke about it. So what we're hoping for is to do things that are now geared to taking us to a better level of understanding. And if you get that happening, while public education at a specific time may be important and would be important for specific issues, but if you have people more generally sensitized to the operation of law and how they can use it and benefit from it and be a part of the legal process, then you find that when you have to do specific sensitization programs, you are already dealing with a public or with the publics, depending on how you look at it.
Yeah.
That are already sensitized to the operation of law, but sadly, we tell people ignorance of the law is no excuse, but we allow them to remain ignorant because we don't know. And you mentioned the diaspora. This is an area, quite frankly, where the diaspora can be very supportive of programs and initiatives being put in place to support that sort of development, which will allow us along the path of greater sustainability as we seek to build our people. And I'd be happy any day to collaborate with a group of persons in the diaspora who are also minded to be supportive of Jamaica and also minded to see us move forward, to be working along with us in doing these things which do not take a whole lot because the initiatives are already available. It's just for critical support to be provided. And quite frankly, I see that. I know as we get to dual citizenship, for example, and we'll have a more concerned discussion about it in relation to the parliament. Quite frankly, I see that as much more critical than whether any dual citizen serves in our parliament, quite frankly. But we'll get to that in due course. We haven't got there yet.
I listened to you, and someone asked a question, and I bring it up a while ago. I'll just bring up that question here, and did Dr. Malcolm reach out to the CRC chair to get his tools applied to the review process? And when we look and we listen to what is happening, and I use this word, and you can come back to me, and I said, with all the so-called maybe noise which are happening around us regarding the different discussions, is it like too much noise? Is it that there need to be some calming of the waters whereby you can have some guiding voices taking the people through, or these noises are really good? I mean, you're into ADR. What's your take on that? And of course, related to that question there, which was asked by Ideas of Jamaica, reaching out to the CRG chair, getting these tools applied to the review process, which we are full on. We're full on in that review process now. It's about to be it's been tabled.
Let me say something which should not be controversial. We do not need to kill any more trees. The information is already out there. We have done a lot of studies.
Yes.
The question is whether or not we are prepared with the relevant political will and prepared to take the hard decisions that are necessary and to do the things that are required to be done. There is nothing that I've said a minute ago that I have not said before and has not been said in the public space. Nothing.
Yes.
So getting back to it, so we're there as to whether or not that is there. And you ask the question, is there a need for a calming of the waters? Let me put my mediator hat on for the moment. Yeah. Because I do practice in that area as well. And I teach in that area too. The fact is, there are two critical schools of thought in relation to mediation and some of these more conciliatory methods of resolving disputes. One of them is that you should, when people come and there are all sorts of hot topic issues and people venting one way or another, you should try to calm the venting in the best way possible and as quickly as possible. There's that school of thought. There's another school of thought which I think is better supported by psychology and psychologists, quite frankly, which is that you should allow people to get things off their chests, allow them to vent. And it is after they have vented and feel comfortable with their venting that you're now able to bring some calm and some order. So there is a space for calm and order, but there's also a space for giving persons an opportunity to speak and to allow views to contend properly, because part of the calming of the waters approach generally that we have to be careful about is that as we calm the waters, we sometimes prevent venting that might allow you to get to an understanding of what the real problems are as distinct from what the presented problems are, getting back, as I said, to my mediation think and speak. That you sometimes have problems presented and people think, well, this is what it is. But the more you delve into it and the better you understand what is happening, you say, oh, that is what they presented. But I'm hearing something different. And I'm understanding that not to be the real problem, but what it is. Let me give you a good lawyer story, which you will understand. We hear people talk, for example, about couples separating because a man squeezes a toothpaste from the top instead of the bottom and something. You are a lawyer, I am one. I have never seen a couple divorce where the real problem was where the toothpaste was squeezed from. There's something else. That is just what they tell you, but that's not the fact. And those are some of the real problems we have when we try to do things which end up masking the problems rather than unearthing them. So what I'm hopeful for is something which is much more along the line of let us hear the voices.
Yes.
Let us understand the grassroots and not let us have a select few, myself included or any other, who will then effectively, with our agendarization, again my word, seek to bring to the public what we say is in their own best interest without trying to understand what is in their best interest and how we can move them forward. And you know, we have this thing sometimes, those of us who consider ourselves to be educated, that we believe others will not understand because it's bigger than them. If it's bigger than them, it's not for them. And if we're thinking about building a society, we can't be building a society that is not reflective of everyone. And we're seeing the us and them approach in it. That is not a society. That is a situation where what we're doing is creating cartels here or there, or castes here or there, or some levels of stratification which we should not be working towards if we're talking about building a harmonious society. And therein lies a big part of the problem as well. So we have programs and initiatives which are very often never geared or sufficiently geared to getting to what the people actually want. We presume it, and we use our approach, and we talk about discrimination, we talk about all sorts of things, but it's by reference to what we see through our lenses. And ultimately, as we say that other people are marginalizing us, we are ourselves seeking to marginalize others.
I'm really looking forward to hear more about the street agenda, the way how you reach out to the communities. And even in this particular program here now, we can pick off one particular issue and see if we can even dissect it as a teaching moment. Let's look at, for argument's sake, okay, the big one which is in the space now is the whole area of dual citizenship. This is something which is to the heart of Jamaicans overseas as well, or dual citizens. We're on the eve of a diaspora conference, which is going to have lots of dual citizens. And you're hearing now this big debate which is happening regarding Mark Golding, swear allegiance to the king, and somehow it is being put as the same level as when it was with Vaz and Danville Walker in 2007. How can the people out from us here now educate what is really happening? What is the law? What is the structure right there to the best of our ability, sir?
Start with that issue, and let me put a few things squarely on the table. My personal position is that no one holding other than a Jamaican nationality and citizenship solely should sit in our parliament. That's my position. But having said that, I am cognizant of the fact that we're a country of law functioning under the rule of law, right? We're a country and we operate with essentially three arms of government, including the court, and it's a court of law.
Yes.
And I also am of a view, clearly so, that if we undermine our legal process and our legal system, we will have nothing else to protect us, because that's the only thing that effectively is able to offer some modicum of protection of the relatively powerless people from the might of the powerful government and all the other influences that go with that, right? So we have to be careful that when we start looking at what is right or wrong, we start at the position of what does our law actually say. Now, if we start with the law, my starting point, is to remember, they say, I have my own views, quite frankly, about the Constitution being what it is. I tell people all the time that while I'm a constitutional scholar in some ways, I wouldn't say I'm the grandest of constitutional lawyers. I'm not. But what I do know is that we hear that the Constitution is, as Hans Kelsen put it, the grown norm or the basic law that must be looked at and examined in all the things we do, and everything should really move away from that. So that's a starting point, and I accept that. But I do have a view that says that ultimately it's the courts that decide and give meaning to everything, including the Constitution. But it's a conversation I'm not going to get into now. But we need to remember this. The Jamaican Constitution is actually a schedule to a statutory instrument which came out of the English Parliament, the UK Parliament. And this was a statutory instrument. It's called the Jamaica Constitution Order in Council 1962. And I'm reading from it. Statutory Instruments 1962, number 1550. And it is, and note what it says, it's for the Caribbean and North Atlantic territories. And I'll get back to the word territories in a minute. And it then reads, Jamaica Constitution Order in Council 1962, made 23rd July 1962, laid before Parliament, i.e. in England, yes? On the 24th July 1962, and it then came into effect on the 24th July 1962, came into effect on the 25th July 1962, immediately before the 6th August 1962, which is when Jamaica became independent. Now let me go back to the word territories. At the time the Order in Council was passed, Jamaica was not a country. It was a territory. Like the British Virgin Islands is, like the Cayman Islands is, Bermuda is, and so on. And in every sense of the word, a part of the United Kingdom. Yes. The Constitution then goes on, if you look to it, to section 39, that speaks about the fact that persons who are eligible to persons may sit in the House if you're over the age of 21, you're of a Commonwealth country, and so on. And then there's a section 40 that says that Section 39 actually says it's to be read subject to Section 40. Yes. And Section 40, among other things, says if you voluntarily, of your own volition, swear allegiance to a foreign country, then you could in fact be disqualified from sitting in our House. And the question becomes, of course, what is a foreign country? But if you're looking at what is a foreign country, our Interpretation Act does not define what a foreign country is, nor does the constitutional order or the Constitution itself define that. So you must then go back to what was the relevant thing to be considered at the time that particular order in council was passed in 1962 in England. And at that time, Jamaica certainly, relative to England, would not have been a foreign country either way, in the same way that the British Virgin Islands and Cayman and so on are today, even today, not to be considered foreign. They're part of the realm, as they say. So to that extent, we can rule out the fact that England is a foreign country. And because the Constitution itself treats with the Commonwealth in the same way, you can also argue further to say that the Commonwealth countries are not to be considered foreign in the context of our Constitution. So to that extent, what it then means is that any argument that we hear being made to suggest that somebody who is a Jamaican citizen, who may also be a citizen of any Commonwealth country, is disqualified simply for that reason, is an argument which has no real foundation supported by the law, going back not just to the scheduled Constitution, but to the order in council to which the Constitution is scheduled.
Yes. Because, I was looking at the 40 for argument's sake, and I've listened to a few other scholars, and the bit which is so crucial is about no person shall be qualified to be appointed as a senator elected as a member of the House by virtue of his own act under any acknowledgement of allegiance, obedience, or adherence to a foreign power or state. I like how you broke down that bit about the foreign power, because that's a big question. What is a foreign power? Because right now, I believe a lot of Jamaicans are actually, well, I don't know if a lot of Jamaicans actually looking at it and say, Mark Golan has an allegiance to a foreign power, which is Britain. A
Well,
common,
what I would say is that, and I hear
yeah,
that, but I've just indicated why I'm saying that
mm,
any sensible reading of our Constitution,
mm,
including by reference to the order in council to which it is a schedule,
yes,
would not lead anybody to come to that conclusion. And
mm,
I would like to be convinced by legal authority, by anyone who says that, as to how it is that they could come to a sensible conclusion that Jamaica, that the United Kingdom is now to be treated as a foreign power.
yes,
Until such time as that law is changed, it is not.
yes,
And I don't see if persons read and understand the history of our Constitution
yes.
and what it actually says that anybody could sensibly come to that conclusion. If anybody does, I'd say, look, you need to satisfy yourself, not just me, that you're making good sense.
So, do you see then, in regards to this CRC recommendation, that
Yes.
this could be a situation whereby the UK then will become a foreign power?
Well, I would expect, and as I said, my starting point is this, that I
Mm,
say I am not hung up on who is or who is not, a citizen of a foreign country per se. But my
yes,
position is that if you're serving in our parliament, you should have a sole allegiance by way of nationality, and that is
yes,
Jamaica. That is my position. Is that
yeah,
what the Constitution actually
yeah,
says at the
yes,
moment?
yes,
No, it
yes,
does not.
yes,
It does
yes,
not. But I'm
yes,
saying as we move to a reform process,
yes,
I would, for that reason, and I could explain why it is,
yes,
that I am not in favor of dual citizens serving in our parliament, which is another argument to be made.
right,
And that's
okay,
an argument I will justify for well, for reasons I have.
yes, yes,
But I'm just indicating what my position is, but also saying at the same time that notwithstanding my position, I recognize that the law is the law and I'm subject to the law.
yes. I clearly see your point right there. So let us look into the world with the diaspora now. For those who are actually saying we need voting and to be a part of the political process in the UK, to sit in parliament as well, because that is one of the arguments which has been going on. And of course, I may be guilty of this because in 2004, 2006, I was one of those persons who brought it on the floor of the diaspora conference that says Jamaicans overseas, what about their right to vote as well? Uh, you know,
You see,
you're
there are two things in it.
mm,
There are two critical issues.
yes,
The right to vote is not necessarily the same as the right to sit as a representative in the House. They're two distinct issues.
mm,
If you have a Jamaican citizenship, which
yeah,
I know you do, right?
mm,
There's nothing to prevent you showing up in Jamaica at election time if you're on the voters list
yes,
and showing an ink on your finger to say, I place my vote. There's nothing to prevent you doing that. However,
mm,
there's a constitutional prohibition if you are in, for example, the US, that would
yes,
prevent you putting yourself forward to sit in the House. So the Constitution itself recognizes that distinction. Because if you look to the Representation of the People Act and all the other things that are related to elections,
mm,
there is nothing that says that a person who is entitled and on the voters list at a relevant time is disqualified from voting
mm,
simply because you have taken on another nationality. Because Jamaica does not prohibit dual nationality. What it prohibits is a dual national of person where the other nationality or nationalities, if it's multiple and not just dual, are outside of the Commonwealth. But what it says is there's no prohibition against voting.
mm,
And I've asked about the diaspora wanting to serve in things. I'm going to answer that question. I'm getting exactly to it because I think
yes,
that's the meat of the matter, really.
yes,
Let me
yes,
tell you what my position as to why, and I started in this way. I ask a question as a law reform person and policy specialist, I might call myself even. I always start by asking, what is the mischief that we want to cure. So I see the question of about persons in the diaspora wanting to serve in the parliament. And my question then is, if somebody, for example, what is the purpose that somebody in the diaspora who does not live in Jamaica, who has no commitment to being in Jamaica, who does not wish to be in Jamaica, but wish to sit in Bristol or Brixton or wherever and be able to fly in for parliamentary sittings or do them by Zoom or miss as many as you can legitimately miss without being carted out of the house. Why is it that you need to be here? And why do you have to do that if what you want to do is to serve the country of Jamaica? There's so many ways you can serve without sitting in the house. Or is it that persons want to serve because it gives you a badge of authority and because it gives you a title before or after your name or something? Is that the objective? And if it is that, then we have a problem. But the question I ask is, if it is that you want to sit in the house and you have a dual nationality and you're so committed to Jamaica as somebody outside, and the dual nationality is the only prohibition, why not give it up and come to Jamaica and live among the people and be available 24/7 every day of the week to people? And at that point, dual nationality is no longer even an issue. But if it is that you're hedging by saying, boy, I want to keep this now in case that doesn't go back, that doesn't show commitment, because commitment by its nature is unconditional. And unless and until you're prepared to give unconditional commitment to Jamaica, particularly a small state as we are, I do not support it. And people may then say, but in the US and other places, there are dual nationals sitting in the Congress. And that's true.
Yeah.
But I then ask the big question. Think of any congressman or woman in the US who has a Jamaican nationality as well, if they do. Whether or not they could ever contemplate living in Jamaica and serving in the US Congress. It would never happen. Nobody would have you there. You'd be booted out. Think about the other thing. I was just reading a new law that was passed in the US just this year. I think it was in January, where they were giving things about dual nationals who serve in Congress. And you know what the first obligation is? To do so, you must show that you are fully paid up and are paying all your US taxes. And the biggest consideration for the US, is that you're paying their taxes. But the other side of it, I go a little further. Those persons who are sitting there in the US and are in fact dual nationals, the majority of them Israeli nationals as well, quite frankly. If you look at, and I've done the research, I know. You look at them, none of them live in Israel. That's one. And the truth is, all of them maintain their assets and everything in the US and their homes in the US. The most they may have is a little kibbutz area in Israel that they may go to from time to time and send their children there, if at all. But what are we expecting now is that the persons who would not be permitted to do the same thing from the other way would want to be able to have effectively maintain the absentee farmer philosophy, which is what England used to keep us enslaved for so long, and have all the benefits go back to England, where you have your assets in England and your liabilities in Jamaica. That is something, and I tell people all the time that the most enduring bad feature of slavery, as far as I'm concerned, is the absentee farmer philosophy, which has hindered our development in ways which we cannot consider. And that for me is a big problem. And the problem that we must remember is that it doesn't work the same way. Somebody who is attached to a big state, UK, Canada, US, wherever, will not behave in the same way when they're elected in a house there as they would if they're here. So for example, we hear that the Prime Minister of Wales, that he was born in Zambia. Hip hip hooray, yes.
The first minister.
I have listened to that gentleman, and I have been to Zambia a couple of times, and I have many Zambian friends. He doesn't sound like any of them. He sounds very British. And I spent enough time in England.
You mean the First Minister of Wales, yeah?
The First Minister, rather, not Prime Minister, the First Minister. Sorry about that. That's okay. I spent enough time in England. I did both my LLM and PhD out in East End, London. So I know how English people sound, right? And he doesn't sound nothing like the Zambians I know. And I say further that he would never dare be First Minister of Wales, but acting in a manner where he lives in Zambia and is showing up in Wales and acting in a manner where his assets are primarily being maintained back in Wales or any such thing. It doesn't happen. And I'm saying to persons who want to serve in our parliament, if you are that bold and that prepared to serve and be the beneficiaries of your good or bad policies and the good or bad laws that you help to make. Come here, suffer with the people, be part of the people, and have them being able to call you at any time of the day and night, and be prepared that when a hurricane comes and the lights are out and the water is out, that you will stay here and not be on the first rescue flight out.
So therefore, you're on a moral crusade right there on that particular point, separate and apart from the law.
No, I'm clear on the law. As I said, I know
you're clear on the law, but at the same time, what you're saying is that the principle and the spirit by what you're talking about is that those in the diaspora who want to come to Jamaica to serve in Parliament, you need to give up. And
you must be prepared to show your commitment. And if you're not prepared to show your commitment,
so you're saying that people in the diaspora, if they have a Jamaican passport and a British passport, they're not committed. If they have a Jamaican,
I'm putting it a little differently, because let me put it another way.
Yeah.
Because there are two issues, and I need to clarify this a bit.
Yeah.
I am less concerned about the passport than I am about the commitment.
Yes.
If it is that you have a dual passport, and you live in Jamaica, as Mark Golden has done and has always lived here, except for when he went to school abroad and so on. And for all intents and purposes, he's as Jamaican as anybody I know. Yes. I am right here in Mona at the moment. If you go up Auguststown and talk to anybody down those areas, they know him from the days of kicking football with them and doing all the other things. He's as Jamaican as they get. He certainly cannot be in the same group as persons who wish to effectively be the helicopter persons, right? Who fly in, fly out, do what they want to do, but they have no real commitment or holding it. And it doesn't matter whether you were born here or not. I couldn't care less. The moment you find that you have effectively put yourself in a position where your primary residence, your primary commitment is to another country, I can't see the basis on which you can then claim that you're going to serve the majority of the Jamaican people, many of whom have to suffer and have no opportunity to leave.
Yes.
And I find it quite wrong and amoral even that persons should even contemplate it. And if persons are saying that, we have this great things that we can do, and you're going to blackmail people because you're talking about remittances and so on, I say not at all. Expunge the thought. We should not be blackmailed. And if people are going to blackmail you by simply saying, well, because we do X and because we do Y, you should create a space in Parliament, I think it's wrong. And I grew up learning very early in my life, in a very proud way, I might say, that if you are going to give me something and then expect me to thank you for the rest of my life, take it back. I don't want it. I consider you to be a hypocrite. Because I believe that you should do things out of the goodness of your heart, because you want to do them. And if that is what you're doing, do not do it. And if you're not prepared to make what I consider to be a real commitment, do not come in and expect people to then make room for you. But then I go a little further.
Yes.
We talk about dual citizens. What are the parameters that you wish to have? Are we going to say it should be only 6 persons or 5 persons or 4 persons? How do you select those? And select them by reference to what? And if it is that you select 6 and there's a 7th who wants to, is that person being discriminated against? I was Attorney General, as I said, in the British Virgin Islands for a while. And small as that place is, in Tortola, you can drive from East End to West End and back twice in 2 hours, and less than 2 hours. That's how small the place is, literally. Yet, in that place, let me just finish this thought for a minute.
Please, yes.
Yet in that place, if you are wanting to represent West End District or the 7th District or the 3rd District, they have them by numbers, and you do not live there, nobody will vote for you. Because their position is that if you do not live in our district, you do not suffer the roads in our district, you do not suffer the light and other conditions in our district, we have no reason to vote for you. We want to vote for somebody who live right here where we are.
So Dr. Malcolm, I don't know. I was sort of going through a bit of the recommendation, but I did not fully go through the recommendation before I came on tonight. shouldn't this sort of thinking, and the Prime Minister has also said the same point, whereby the ultimate leader, I don't want to use the word ultimate leader, but anyway, the simple mischief of what he's saying actually is that the Prime Minister should solely have only one allegiance, and that is to Jamaica, not to Britain or anywhere else. That's what he's actually saying. But the recommendation is not saying that.
The recommendation is not saying that, but I will respectfully disagree with the Prime Minister on that, and in a very strong way.
Yeah.
This idea that the sole leader, but nobody else, doesn't make a lot of sense to me for this reason.
Yes. Yes.
We do not have a directly elected Prime Minister
President.
system.
Yeah. Yeah.
We have a system where once you are elected, it is the person who commands the greatest respect of those in the majority who is then recommended who becomes Prime Minister. That's one. Secondly, in substance, whatever you hear, we have government by cabinet. And cabinet is comprising all the persons. So the Prime Minister is just one voice in a cabinet of persons. And so decisions are being made by a number of persons, not just the Prime Minister. And the decisions of cabinet is collective responsibility. And I've sat in a cabinet, so I know how they function, right? And what I'd be saying here is that if that is what you want, let us go the whole hog and take the position that once you are there, we get rid of you. But this idea of pandering, which is what I consider it to be, should not happen. Do we want to go the Singapore route, for example? We probably could. In Singapore, they say you can only have one citizenship, and it's Singapore. And in fact, their position is, even if you were born Singaporean and you live out of Singapore for, I think it's 10 or 12 years, whatever the period is, you automatically lose your citizenship. And they say something else in Singapore, that to become a member of parliament in Singapore, you do not have to be born in Singapore or even have any maternal or other connection to Singapore. Once you become a Singapore citizen by birth, by naturalization or otherwise, and have lived there for at least 10 years, you are eligible to be elected to their parliament. I support that system. Why is it that we have a problem?
Very strict as well over there, yeah.
They're very strict. I've been there a couple of times, and I must tell you that there are many things about Singapore I do not particularly like. But that is something I'm saying, if we're talking about principle on the question of dual nationality and so on, and we want to talk this thing about, oh, the Prime Minister should not, and the leader of the opposition should not, that for me is splitting hairs in a way which makes absolutely no reasonable sense to me, and certainly not by reference to the system of governance that we have and the method by which the leader of the opposition and the Prime Minister is chosen. If we're going down that route, have a clearing out and simply say, here is what it is. And as we go down the constitutional reform process, make a clear and definitive position on whether we want dual citizens or not. And let me be clear on this.
Yes.
While my personal view is as I have expressed it, I am subject to the law. And if the people decide that they want dual citizenship, I am the first person who will hold my hand up and say I am subject to the law and will be supportive of the law. So I'm not in a position where I'm saying that it is for me, because I already started by saying we should have the people. And that is why I said at the beginning that I was happy when you said put it to the people. Because if the people ultimately decide, who am I? However reasonable I consider my voice to be, to say we should not have it. But what we should do is that in the process of getting the people to decide, we should have frank and honest and open conversation, and we should speak around the elephant. We shouldn't just speak around the elephant in the room. We should call it out. And part of the calling out is to say that the diaspora has served us well, and we have benefited tremendously from the diaspora. But there are also elements in the diaspora, quite frankly, that have been more interested in their personal embellishment and their personal, titling and all sorts of things. And some of them have not served us as well. Because when I hear, for example, the argument being made that if you don't do this and you don't do that, we should stop the remittance flows and so on. The remittance comes to your family members, quite frankly.
Come to family.
So
I always say that all the while. Don't hijack Jamaica or so on that basis there, because remittance goes straight to your family.
Exactly. So that is a non-starter in my view in terms of the argument. We shouldn't go there. We should speak by reference to principle, and we should speak by reference to, as I said, whatever my principled position is. If the people decide that they want it in a particular way, I'm going to support it because I believe in the value of the law and in the voice of the people.
Yes. I just jump into this point here about the point which Mr. Golden had said, that on the table they need to have the Privy Council and the CCJ. Well, more the Privy Council to get rid of the Privy Council. What's your take on that in regards to the Privy Council in this whole recommendation, even though it's not entrenched in the Constitution?
Right. My view again is, and Duke Pollard, who was a Guyanese, but he lived many years in Jamaica and practiced law here as well.
Yes.
And he ultimately went to the CCJ as one of the first judges there. And he was a significant voice in the drafting of the relevant laws and so on, the regional treaties and so on, that led to the establishment of the CCJ. And somebody who I was very close to. And he has this book, I have a copy of it on my shelf somewhere there, which he wrote about closing the circle of independence and speaking about the role of the court in closing that circle. And very often we speak about the court simply by reference to its role in the dispensation of justice, without recalling its critical role in governance, and that it is a critical creature for sustainable economic development and all the other things that happen. Going back to my earlier point about the law and the value of law and the fact that law is in everything, we need to also recognize the value of the court and how it functions in that. And let me digress for 1 minute. A lot of people don't even realize, some persons on the call, even who are British, the value of legal services to the UK economy. It contributes about 8 to 10% to your GDP every single year. And I'm sure many of the persons, even from England, do not understand that. So legal services is critical, and it's a significant element of your building of your economies.
Yes.
So I am one who believes certainly that we should be careful how we're looking at our courts, not just by reference to justice, but by reference to its broader implications. And I have said publicly, and have done so for the last 20 or so years, that I'm in favor of the CCJ, even before the court came officially into existence in its operation. I have been saying that. And in fact, if you look at the Max Planck Encyclopedia for Public International Law, the CCJ article in there, as well as the CARICOM article, are articles that I wrote. I co-authored them. Well, I wrote them with Sir Dennis Byron, who was a former president of the CCJ, right? So I've been well into that. But having said so, we have to be careful. And I've said this again, that as we're speaking about moving away from the CCJ into the Privy Council, rather, into the CCJ, we recognize that in the same way that the Privy Council is not really, it's a court which exists in service to Jamaica. It's a court of Jamaica. It's our apex court.
Yes.
The CCJ will, for other reasons, be in a similar position, but it is much closer to home, and it is something that we've contributed to. We've worked towards it, and so on. And there's an alternative, and the reason I've mentioned that is that there's another argument that has been made, quite frankly, for a long time. I first heard that argument coming out of the late Dr. R.B. Mandison Jones, who had a close listening ear, I understand, to Mr. Siaga. Mr. Siaga's position was essentially that instead of the CCJ or anything else, if we're talking about moving anywhere, we should move to setting up a final court for Jamaica, which is Jamaican in every sense. I am not as supportive of that idea. I'm more supportive of the CCJ, but again, the people decide. And I think with the Syringa Marshall Burnett matter that happened several years ago, we found ourselves in a position where, even though the Privy Council said there was no need for a referendum, effectively we ended up being locked into the need for a referendum because of how that case manifested and the trajectory it had. So we are now in a position where, fortunately or unfortunately, that too is a matter for the people. But my personal preference, and I hope we get there, is for us to have the CCJ as our final court of appeal, and that we can move to building out a truly regional jurisprudence. I tell people, for example, my favorite case is the case of Mitchell and Cowie, which was a case that came out of Trinidad and Tobago. Former Chief Justice Wooding, now deceased, was critical in that. And it was a case that decided that the chattel house was not fixed but movable property. And you know the idea as a lawyer, which is that what is fixed property becomes part of land. And he said, no, we're coming out of slavery. where people did not have land, and the little money they had, they were able to build their little chattel houses, which is board houses on stilts.
Yeah.
And you would
Yeah.
see in Trinidad, Guyana, and even parts of Jamaica, more so in Westmoreland and so on, where people will simply use a truck and pull the house when they get evicted from one piece of land to go put it on another. And he decided that we had to recognize the nature of our region. And I couldn't see that decision coming out of England, quite frankly, but I saw it coming out of the Caribbean. And I think we have sufficient bases for saying we want a court, getting back to my point as well, that the court is not just about justice, but it's about the building of sustainable economy. To say we need to have a court which is more reflective of us and on which we can effectively rely as we seek to build our continuing independence and who we are.
Thank you so much for that. And ladies and gentlemen, I want to thank you so much for joining me tonight. I'm with Dr. Christopher Malcolm, Senior Lecturer and Deputy Dean at the University of the West Indies, Faculty of Law, Mona, Attorney at Law. And I have a young gentleman here, Mr. Action Now, J.A. You're on mute, Action Now, J.A. And are you there? Let me see. He's frozen with a smile. Are you there? Can I hear you? You're on mute. You're muted. Sorry. I don't know. I'm only seeing his smile. But anyway, I think one of his points, until he comes back in, one of his points was really pushing about this final court at the same time. And the Prime Minister, I believe, alluded to it about this final court for Jamaica. Action Now, are you there? Can you hear us?
Greetings, Mr. CDL.
Yes. How are you? And Mr. Okay, I think he's got some issues there in regards to his thing. Yeah, I know. Let's go back to that point. Let's go back to that point. Let me just. I think he's got a. I think he's got a problem. Okay, sorry about that. Some issues there. So are you saying then that the Privy Council can stay while we leave the king?
No, what I'm saying here is this, is that I am not a monarchist by any means. Let me start by saying that. Right? Not by any means. And I hold no allegiance to the personal allegiance, notwithstanding the country allegiance that I hold to the king. Right? So my personal view is very clear on that. I am one wanting to have a clear break from the monarchy.
Clean break.
And that break, in my view, must properly include a break also from the court, the Privy Council. How we get there is a matter that could have all sorts of implications, but the most important being that given the nature of our political arrangements and what is now required, there is need for political consensus on the matter. Sadly, we have not over the last 60 plus years had the required political consensus to get us there. And don't get me wrong, this matter of the moving to a final court away from the Privy Council is not new, It has been around forever. Since independence and all of that, it has been. In fact, our librarian here, in the Faculty of Law, Ms. Douglas was pointing out to me that recently she was looking at some Hansards, and there was this matter brought before the House from as far back as, in a formal way, back in the 1970s, early 70s, about getting rid of. So it has been there, and all sorts of things are out there which we need to examine. What the PNP has said, if we're not going to take it to the politics, the JLP has taken a position, frankly, it appears, to say, look, we need to get rid of the monarchy, and the question of the Privy Council can be subsequently dealt with. Privy Council, i.e. CCJ, yes? The PNP's position, which is consistent with one they have held before, quite frankly, is one that says that we believe we should have it all dealt with together. And the reason I think for that, again, we're not going to talk around no elephant in the room. We're going to talk about it. It is a question of political trust. Let me use again an example I can speak. In the British Virgin Islands, they have a situation where they got a new constitution, albeit still a territory, right?
Yes.
In 2007. And at the time of that constitution, when it was being negotiated, they ended up with a constitutional provision which allows for the governor, who is a British civil servant, quite frankly, but the king's representative in the British Virgin Islands, to chair their meetings of cabinet. Now, this position is unique. It's not the same in every British overseas territory. And you know why they got to that position? They got to it because at the time that constitution was being negotiated, the then opposition could not, and I know that to be the case, did not trust the government and by extension the premier to chair cabinet in a manner which they think was not inimical to the interest of the opposition.
Yes.
So as a result of the lack of political agreement, they ended up with a situation of having the governor chair their cabinet. And I can tell you, having served there, that that is a matter which over time both parties have come to be unhappy with, because very often matters come up and they're like, well, it's the governor, we should be able to do it ourselves. But the truth is, there was a question of political or distrust between the political parties. And I suspect that at the core of all that is happening here, said or not, is a fundamental question of distrust, right?
Yes.
And until we get over that hump, and we're able to get to a point where persons trust each other, and that a process will be agreed upon and will move forward in a particular way, then we're going to have issues. Okay. And so, again, we get back to how do we get to the political consensus? And I think that's a matter, quite frankly, again, where the diaspora, persons in the diaspora, can be of assistance in helping to forge and assist to bringing that consensus that may be necessary. Because I think there's so much that can be achieved if we have political consensus, not just in relation to that. Again, I was in the BVA, and I'm going to give you one small example of why consensus can be so important. There they have a situation where there was a time when their so-called financial services sector contributed 60 odd, up to 70 odd % to their GDP. And I say so-called because at the core of it is a legal services arrangement, which then allows for the building of the offshore banking and, well, not so much banking, offshore arrangements around. It's all about legal arrangements that it is. And they recognize it even though they may not say it. Yes. But in relation to that, because of the value of it to their economy, they have a decision which says that we do not quarrel about the financial services sector in our parliament. So I have been there and I've been involved in the process where there's new law or amending law to be passed in that sector. You know what they do? All the politicians and the technocrats, including the AG, will meet prior to the sitting of the House. And they will then ask the technocrats all the critical answers as to why the law is needed and go through it, the draft, line by line prior to the sitting. Yeah. And once they're satisfied, they will go in the House, and however voluminous that act is, it will be passed within an hour. Because they take a position that we're not going to quarrel over the goose that lays the golden egg. And I think in the context of Jamaica, as we move forward, being a small state ourselves, we must also agree on things and say these things are beyond politics. And we should do them because it is in the best interest. And we should know that there's a level of political trust from all sides towards each other. That will allow us to do that.
Yeah. Someone said, totally agree on a clean break. A step-by-step approach is a suspect and open to political manipulation. So the people need to decide now. Just stick up in on that point there. Do you think then, I know I like to sort of talk about coming together and of course the simmer the waters, but do you think that the PNP and JLP should really sit down together in regards to this key area regarding the Privy Council and not turn it into maybe a political tool and really move together to sort of having that break?
Well, I'm going to say this. I'm sure that there have been sitting downs together on many occasions in the past. And I also believe, quite frankly, we have sensible leaders, you know.
Yeah.
And whatever the political hustings are, I have no doubt that you will have further sitting downs at some point.
Yes.
But the question is not so much whether there's to be a sitting down. The question very often is how do you ensure that after the sitting down, you have persons leaving feeling sufficiently confident
Yes.
in agreements that have been arrived at, and that
Yes.
those agreements will be honored to the letter.
Yes.
And again, it's the elephant in the room that we must confront. How
Yeah.
do we get the level of political trust and the level of commitment that we require to get us to a point of agreement? And remember, in all of this, and I'm not suggesting dishonesty on the part of anybody,
Yes.
because we must also remember that positions are very often adopted because people hold particular views for one reason or another.
Yes.
And those views are, even if not justifiable to you or I, they may be justifiable to them. And we,
Yes.
again, should not impute motive or malice or any such thing. So we should understand in our own thinking that as we're looking on a process, we must also believe that the persons who are in the process know better than you and I why they adopt the particular positions that they do. Sometimes those positions need to be refined.
Yeah.
Sometimes they need to be revisited. But we also know as humans that sometimes for pride or for other purposes, when we adopt positions, we find it difficult to move away from them. So the question is, are there other impediments that are there that could be helped by additional persons in the room and persons who may see things a little different and
Yes.
can become more effective mediators or whatever to assist the process along?
Thank you so much for that. I've got action now, Jay. Let me grab it before anything happens with your Wi-Fi. Thank you for coming on. You know, go ahead and OJ. OJ is in Jamaica right now, and he was one of those independent party, but a very very vocal young man, and I like having a conversation with him. So he's got some questions to you, sir. Yeah. Go ahead, Uj. Can you hear us? Yes.
Yes, I can. I thought I would be asked a question.
No, you to ask the question.
I'm sorry.
No, you're to ask the question. That's what.
Okay, Mr. Malcolm, you mentioned that, and good afternoon, by the way. Good afternoon, and thanks for having me, Mr. Sidiel.
Yeah.
Good afternoon, Mr. Malcolm, and to the audience.
Yeah.
Right, you made mention of our final court should be the CCJ, right? I would want to ask, why is it that we should then have to, take a plane, or why should we have to travel to another country to have our legal matters heard?
Let me ask you. You say I said our final court should be the CCJ. Yeah, that's my personal view is that we should adopt the CCJ. But when you're saying why should we travel to another country to have the CCJ to have matters adjudicated, you're talking about by reference to the CCJ?
Yes.
Well, there are two things. If you're aware of how the CCJ functions, you would know that you do not actually have to travel to Trinidad. They have traveled elsewhere and are always ready, willing, and able to travel to wherever the countries to have their sittings. And they started doing that a long time ago, quite frankly. In addition to which, they hear a number of matters and are well equipped to have a number of things done, certainly for preliminary matters and so on, by reference to using online. But the other question I might also say is that I know, and you probably do, that it is much more affordable to travel to Trinidad, even if you have to go there, than it is to travel to the United Kingdom. That's one. Hotel rates in Trinidad are considerably much cheaper than hotel rates in England. The rules of the Privy Council require that you retain local solicitors in England. Those of the CCJ do not, and the local solicitors in England are not cheap. So if we start multiplying costs and doing all the other things, you find that the question that you have raised on a pure economic basis means that we're better off with the CCJ than the Privy Council. If it is that you're suggesting, let me just preempt you a bit, that instead of having the CCJ, we should have a final court, which is purely in Jamaica, sitting only in Jamaica. If that is the approach you're adopting, I am saying that one of the problems that we have in our justice system in Jamaica, and again, if we're going to speak about the elephant rather than around it, is that there are many persons who have issues with the local jurisprudence and the resources that are made available. Not because our judges are bad or anything, that's not the point. But there are persons complaining every day about resources that are made available to our courts and all the other things. Now, if it is that we're already speaking about resource constraints in relation to two levels of the court, the first instance and the Court of Appeal, do you think that overnight at the higher level of a third branch above that, you're going to end up with resources constraints miraculously disappearing? There's also not just resources by reference to financing, but resources by reference also to the persons that sit. One of the things we have in Jamaica, not elsewhere in some parts of the Caribbean, is that we have consistently to date pretty much said that all of our judges should be Jamaican. In the rest of the region, if you, for example, go to Belize now, two of their Court of Appeal judges, Justice Sandra Minot Phillips and Justice Margaret Woodstock Riley, are both Jamaicans. One Woodstock Riley lives in Barbados, but she's Jamaican. And the position of Belize, the former Attorney General, and I were classmates and we speak often. She has made the position quite clearly that, look, unlike Jamaica, we choose the best talent wherever we can find it, including from Jamaica, and we get them in our courts. We can't say the same for our courts. Are you then also suggesting that as we move to this third tier, we should also create new rules that make it possible for us, if the circumstances merit, to be able to have judges from elsewhere coming in? And the reason I mentioned that, is that there's a point about insularity of thought. For example, however well everybody can sing in a family, if you're putting a choir together, it is not advised that you simply put it together simply of family members, because the timbre and all the other musical things that you can speak about tend to come out similar, even if one is bass and one in soprano, because of the family connection. So you tend to bring diversity. And in educational institutions, for example, you tend to get greater ratings by showing your diversity of thought, right? And the truth is, we live in an environment where not everything is purely political, or not everything is purely domestic either. So you very often need to have voices that can be counter and that can see things from a different level as well. And that is part of the value that the CCJ has. The CCJ has judges from across the region, and it in fact has the capacity to have judges even from outside of the region, if appropriate. Justice Witt, for example, who just died, who was from St. Martin, or St. Martin as they say, was a judge who was not coming from the regular common law system, but he made one of the most valuable contributions you could find to the CCJ. And we have had others. Justice Hayton came out of the UK, and he had significant experience in the areas of trusts and so on, made a valuable contribution to the CCJ. In fact, one of the areas of improvement I think that the CCJ could have is to do something, for example, like the Hong Kong final court does, which is to ensure that they have a set of judges who are Hong Kong judges, and they have what we call a panel of adjuncts who they choose from England, New Zealand, Australia, Canada, wherever in the common law world, who are adjuncts who they call upon from time to time to supplement their bench, particularly with particular areas of expertise, to make the jurisprudence richer and to ensure that you get better out of it. So even though I am in favor of the CCJ, I'm not suggesting it is perfect, and I'm suggesting it could do with improvement like any other court. But I'm also saying that the Privy Council, in my view, is not our best option, in my view. And I'm also suggesting that though the Jamaica option may appear to be a more comfortable option for some persons, for a number of reasons, some of which I won't have time to go into here, I'm less in favor of that than I am in favor of the CCJ.
Sorry, you mentioned before we go to action, and welcome, Herbert, the adjunct idea. It's a fantastic one. But Lord Reed recently just said he's got the go-ahead now for Caribbean judges to go on the Privy Council.
Let me answer you before you even go any further. There's nothing new, nothing novel about that. Nothing new, nothing novel. And there's no need for any change in any law in England for that to happen. In fact, The last Jamaican who sat on the Privy Council was Edward Zaka. And the last case he sat in was the what's Lambert Watson case that came out of Jamaica. And after him, I think Justice Della Bastide out of Trinidad also sat there, and there have been other judges. So the reason that other judges were not sitting on the Privy Council in that intervening period since then was because they were not being invited by the Privy Council. So there's nothing new or exciting about that, quite frankly. Nothing, absolutely nothing.
Okay, thanks for that. Action now, or Herbert, you want to ask any Action? What was your view in regards to what Mr. Malcolm has said?
So I understand. It's really the Privy Council or the CCJ, right? I think as a contingency for now, because I still believe in true sovereignty, right? I still believe in that. I still believe that every country should have its own jurisprudence or ability to adjudicate its own matters, right? So, but I mean, we can take the first step to establishing or to being a part of the CCJ, right? Mr. Malcolm made mention of resources and so on and so forth, and competence, and the whole justice system in Jamaica. I understand. So I would understand that from a contingency standpoint, yes, we can take that first step. But I think ultimately as a nation, we should still aim to have that final court in our country. Yes, the elephant in the room.
Action. When I say competency, don't get me wrong. I'm not suggesting that our judges are incompetent. I want
I understand.
To be very clear. Yes?
Yes, I understand. I completely understand. Yeah. So I understand your point. And I might lean to that recommendation somewhat. But as I said, I think it's that could be a first step we can make to partner with the CCJ or be a part of the CCJ, but ultimately establishing our own final court of appeal in our country.
Thanks.
Before Herbert comes in, let me add something. We need to understand, that at the end of the day, Jamaica is a small society with a population of under 3 million, right? There are some matters affecting small states, particularly ones with limited resources, that we should never overlook. You ever hear them talk about hanging your basket higher than you can reach it?
Don't put your hand where you can.
You have to be very, very careful. And so, with the greatest of intention, they tell you that you must set your ambition where you can reach it. That's a short of it. So while it is that I am saying to you that this idea that Jamaica should have its own and blah, 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 the question is, how do you functionalize that? How do you do that without diminishing other things? And if we have already committed and spent a lot of money on the CCJ, and it is possible to serve us, and we can have a critical input in it. For example, we have no say whatsoever in who the judges are who get to the Privy Council. None, zero. We do have a say, including by reference to treaty provisions and so on, of who the judges are in the CCJ. And there are a number of functional arrangements around the CCJ that would allow us to have critical input in what is there. And it is designed in a way, quite frankly, to avoid the politicians overreaching and effectively influencing selections and so on. But the fact is, the arrangements allow for us to have some critical involvement to the extent we don't have any. We just saw, for example, the Rule 23 amendment that was proposed by the CC Privy Council, which ultimately got struck down. And what happened there? And I made the public point about it. And I said it this way, that when the Privy Council and Lord Reid and the others came up with that proposed rule amendment, they seemed to have forgotten something or didn't care about something. That the Privy Council, even though it sits in England, is in fact a court serving in it as the highest court of the several jurisdictions it serves. To that extent, when it sits as a Jamaican court, it is subject to the Jamaican Constitution. And they were operating in a manner, quite frankly, which was either oblivious to or uncaring about the Jamaican Constitution. Hence, a challenge was made by our lawyer through our bar officially. And as a result, it having been considered, that was withdrawn, as well as the practice direction, which people tend to forget, which predated that proposal, which had already caused them to do what they were already doing. And I was public in saying that I found it unacceptable for many reasons, including by reference to governance and the fact that there was this almost condescending approach to saying we can do whatever we want. Who are you? Right?
Yeah. I have a point which I want to bring up, but I'm going to let Herbert come in first. A point which I hear a lot about the CCJ vis-a-vis the Privy Council. But Herbert, if you have a question to ask, Mr.
Good evening, gentlemen.
Thank you so much for coming.
Yes.
I think, and this is my opinion, there's a certain level of hypocrisy coming out of the sections of the Jamaican society and the Jamaican government not wanting to move away from the Privy Council and choosing the CCJ, right? We referenced Shanice Mary. The CCJ actually traveled to Jamaica to hear that case. When that young lady that was abused in Barbados a few years back. Yes. Now, Pratt and Morgan, they were sentenced to death in Jamaica in the late 80s, I think it was, sometime 1980 something. And the Privy Council ruled that for a death sentence to be carried out in Jamaica, from the appeals must be exhausted within 5 years. It took 15 years for Pratt and Morgan to get to the Privy Council. It took 10 years for Palmer's case, Adidja Palmer, to get to the Privy Council. How can we effectively say we're adjudicating over people's life when to get to the court Privy Council we have to pay millions in airfares to come and represent someone? And we call that justice. I think from the 1990s, one sector of the Jamaican government has been saying CCJ, the others hell-bent on staying with the Privy Council. How can you remove yourself from the monarchy but still want to remain in their backyard as a house nigger? If that makes sense.
Yeah. Okay, Herbert. Thank you.
Yes.
I suspect that was a comment rather than a question, because the point and the reason I take it like that is that we have to be careful how we seek to look at jurisprudence and what happened here, there, and whatever, without a proper discussion of it. So you, for example, mentioned the Adidja Palmer matter, that it took 10 years to get to the Privy Council. How much of that time was attributable, for example, to delays that actually happened in Jamaica? And would it have made a difference as a result of how those delays came about, whether it had gone to the CCJ or anywhere else? I don't know. I'm just saying that without doing that level of assessment, that's dangerous. I'm also saying that we have to be careful to remember this, that every court, wherever you find them at any point in time, will operate by reference to what we call policy considerations at various times. On the 24th of April this year, in fact, that was when Lord Reed spoke at a program I organized. We were looking at the question of judicial policy construction and the considerations, the non-black letter law considerations that judges tend to apply when they make decisions. And what we understand, if you look at case law over time, is that judges will be informed or influenced by a number of factors. So, for example, there are some judges, you hear in the US context, for example, some judges being described as liberal, some being described as literalists, some being described as conservative, some being described as all sorts of things. And the fact is, in the same way that you're a person before you become a priest, you are also a person before you become a lawyer and ultimately a judge. And we are all influenced by biases. And the truth is that you will find benches which are more, benches meaning the panel of judges, which are more conservative or more liberal from time to time. So, for example, getting back to the US, we heard about Roe and Wade and that decision that was made, what effectively allowed for abortion. And in recent time, another decision has been made that has effectively curtailed a number of those rights. The truth be told, if persons want to admit it, is that at the time of Roe and Wade, the bench of the US Supreme Court was much more liberal than the current one. So that benefited from a liberal court. And I'm not here pronouncing on the philosophy of abortion or anything to do with it. I'm just speaking of the nature of courts. However, this court, being much more conservative, took a different approach. And you will find the same thing. The current CCJ bench of Saunders, a Saunders-led court, is not the same as the De La Bastide court, which it started out with. The current Privy Council court, led by Lord Reed, is not the same that Lord Phillips had, and so on and so on and so forth. So we have to be careful that as we assess, we recognize that it is human to err, infallible to be divine, and that our human frailties will always impact the way we decide in whatever endeavor we get involved in. So as we speak about the minutiae of things, we also need to have a grand vision of them as well, and to recognize that what we should be focusing on are policy considerations with the best interests of the people in mind, and a process which is respectful of and engaging of the people, rather than one in which some of us, myself, you, or anybody else, feel that we have an inherent right to simply speak down to people and tell them what is in their own best interest.
So Chris, one of the things people sometimes say, following from the Adidja Palmer Vibes Cartel case, and on recently the Lauren case recently that went to the Privy Council, people are actually saying that they are more feeling that the Privy Council can give them justice more than the CCJ. That is one of the views which is coming out. Have you heard that? And of
Let me
course,
ask you one question. One question before I go further.
Yeah.
What was different about the Privy Council decision than in the Court of Appeal in Jamaica? The Privy Council upheld the Court of Appeal decision in the Miguel Lorne matter.
Yeah.
What was different? How do you tell me that the justice that he got in our Court of Appeal is different than what he got? The only difference being that the Privy Council was the final court and there's no further appeal beyond the Privy Council.
Yeah.
But the same decision that was rendered in the Court of Appeal was also rendered in the Privy Council. In the Miguel Lorne.
And there's no reason to believe that the CCJ would be otherwise.
We don't know that. We don't have any reason to believe that.
Yeah. So therefore, it is. I think the genie is about how to dispel this whole Privy Council thing, and how can we just get rid of the Privy Council? I know, of course, politically it's a political decision, but people are actually saying this is something that should be dealt with at the same time.
Ideally, frankly,
you
want to have a clean break which deals with everything at the same time.
Yes.
But in life, again, putting on my mediator's hat again, if I may, one of the things you learn in mediation is that while you want an ultimate decision, what we learn is that as you get concessions, you record them as agreements. And by the end of it, you will have a big agreement. But sometimes if you're waiting for a big overall agreement all at once, you will never get it. But what I think is critical is not whether you get everything at once, but whether or not the process is capable of being trusted to say that if there is a structured way to getting us to the end, it is going to be honored and not in the breach, but honored, and people can trust it to say that my handshake and my word is my word, and it is going to be honored and shall not be changed. That, I think, is the real danger, because as human beings, we tend to be distrustful, especially if the history is one where persons have seen where there has not been that level of commitment and there has been flip-flopping. And the truth be told, even in relation to the CCJ, we have had flip-flopping. So let me give you a Trinidad example, for example.
Yes.
Basdeo Pandey, now dead, in Trinidad.
Yes.
When he was in government, he was fully supportive of the CCJ and even gave the land on Henry Street where the court sits. He made it available. Then he got into the opposition and it became a political thing in his favor to argue against the CCJ. So his party changed their views on it. And so we've seen those things happen. So let us not
Well,
fool ourselves into thinking
that
the politics of change is not one which also involves the politics in which people's minds can be changed and are oftentimes changed.
And that is the hypocrisy I'm talking about, right? Where depending on what time of day it is or what month of the year it is, you make an argument to suit your narrative.
But everybody does that. What is so strange about
Right.
that? We all do it. Each of us do it in our own way. So let us not get into this thing about he says, she says, and what about is him. While I'm here, I am not here with a political agenda at all. And I'm not here about whataboutism. I'm here about getting solutions. And if we get into this thing, I tell people all the time that the only thing I'm interested in is drawing a line in the sand and saying, I don't care what happened yesterday. I care what happens from today on. And the moment I hear too much about whataboutism and what has happened, blah, 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 I get disinterested, because that is the clearest way of telling me that we're not going to move forward.
Action now.
But Mr. Malcolm,
Yes.
You often say about addressing the elephant in the room, right?
Yes.
And to me, it looks like we are the CCJ is pretty much the bandage to the I'm gonna say now, the legal wound that we have in this country, as opposed to really assessing the players in the justice system, as opposed to reforming our justice system, whether from scratch. You spoke earlier about the grassroots approach, right? The elephant in the room is our political leaders, right, and our public officers who serve in the various offices in our country. That is the elephant in the room, right? And yes, we have problems in Jamaica in our justice system, right? And again, the conversation sounds to me like, yes, the CCJ is that bandage, as opposed to calling a spade and say, hey, the corruption that saturates the political processes and the judicial processes needs to go away, right? That is where our conversation really needs to be, right? Call a spade. The elephant in the room is the corruption that is eating away and impacting all of these other systems that should be working in the best interest of the Jamaican people. You understand? So that is what I get. Maybe I'm mistaken, but that is what I really get from the conversation.
Let me ask you something, Action. Let us now have the conversation, which is purely about the issues. Let us take the politics out of it. What has been your observation, if you have observed anything, about how the CCJ has functioned? How much do you know about the CCJ?
To some extent, I have in recent times just started researching and so I'm not 100% equipped to speak on the function
so
of
the
the
short
CCJ.
is, so let me ask you, I'm not talking as a lawyer now, so I can cross-examine you. Right? All right. So you're admitting that you know very little about the CCJ and how it functions.
Accurately so.
So if you know very little about the CCJ and how it functions, what is the proper basis on which you can opine about the CCJ?
And I'm saying because
No. Stick with me for the minute.
Mhm.
What is the proper basis on which you can opine about the CCJ?
You're being cross-examined, Action.
All right, the reason for my stance, or the
No,
reason
I'm not
for,
asking about the reason. We haven't got there yet. Do you agree with me that if you know very little about something, you're in no proper position to talk in any definitive way about them? Do you agree with me on that?
Accurately so, I agree.
Yes,
with
so if you have already agreed that you know very little about the CCJ, and you're now speaking about them in tones suggesting maladies or anything related to the CCJ, would you also then admit, which you must, that you probably need to do a little more research and find out more before you can speak about the CCJ? Would you admit that?
To some extent.
Okay, so now that we have admitted that, the question that we will now get to is, what are the questions about whether or not people know enough about the CCJ, know enough about the Privy Council, know enough about any other option that could be applied, and whether or not we have had sufficient education and other things around it that will allow us to be able to make sensible decisions. And in that regard, I ask you, we had a very public forum here on the 19th of October last year, which again, I was critical in organizing, that looked at Jamaica at a crossroads and whether or not we should adopt the CCJ. Were you aware of it?
No.
So you were not aware of it. So it's online. You can go and find it. It is still there. The information is still there. And then we had on the 24th of this year, April, just gone, something again which advanced that conversation a little more. What I'm trying to say is that you, me, Silburn, Herbert, and everybody else can use our own initiative and can get involved in processes that can assist public education and to get persons to better understand and to draw the line in the sand and say we are doing this in the interest of the people, in the interest of public education, in the interest of getting people to better understand the issues. So when we act and when we speak, we're speaking from a place of knowledge rather than from a place of parroting views that we have heard, many of which we cannot substantiate because we don't know the information.
You see, the point we just come out here right now is the whole point which we started off with. It's about the education process. It's about ignorance of the law is no excuse. But how can you say ignorance of the law is an excuse when you keep the people ignorant at the same time, Sir Malcolm? And
yeah, but there are some people who do not take enough opportunity to learn even when it's presented either. Because I would say that when you put yourself in a position where you're going to, there's nothing wrong, you know, you don't have to be a chef to be able to criticize the cooking, but by God, eat the food before you criticize it.
Yeah. I'm sorry. Action. Were you criticizing the CCJ or the Jamaican court system? Somebody just pointed out a while ago. He was critiquing.
Yeah, and that is why I wanted to clear the air. But I understand what Mr. Malcolm was saying. I wasn't criticizing the CCJ because, as Mr. Malcolm and I have declared, that my knowledge is not at that level about the CCJ, but based on the conversations that we're having, right? The Privy Council is there, the CCJ is there, and then Jamaica is here, right? And then the conversation is between the Privy Council and the CCJ because of the many things that are happening in Jamaica that would then make Jamaica unfit to adjudicate its own matters, right? And then I'm saying, then obviously the elephant in the room is not the Privy Council or the CCJ, it's on the island. Why we don't have the justice system that is able to adjudicate the matters that we need, as opposed to we having this conversation about the Privy Council and the CCJ. Understand? So I'm not scrutinizing the CCJ, right? But the obvious elephant is Jamaica's ability to deal with its matter at the level where the people.
All right, let me give you two examples from in the region that might assist this conversation. In the 1970s, when Guyana adopted its Republican Constitution, they got rid of the Privy Council. In the 1980s, early 80s, it was, when Maurice Bishop and them came in with the New Jewel movement in Grenada, they got rid of the Privy Council. Now I'm going to answer you in this way. In Guyana, they had a system of having a two-tiered system of the courts, which ended with the Guyana Court of Appeal. And they found over time that there was a level of politicization and all sorts of things related to that and in how the arrangement is. In fact, since Justice Desiree Bernard was the last chancellor appointed in Guyana, she is now dead, and she went to the CCJ as one of the first judges there. She's now dead. They have still not appointed a new chancellor because they can't politically agree. And they found that the system for political interference and other reasons at Guyana became a problem for them. Guyana was one of the very first countries that went to the CCJ. They pushed for it, they went there, and they're happy with the CCJ. And I'm not suggesting that that is why Jamaica should go there. Grenada went and also got rid of the Privy Council and decided to have their two-tiered system of thing. That too worked badly for them. And then they had the Maurice Bishop, the 20 who were accused, right? coming out of that issue there when Maurice Bishop was killed. And interestingly enough, by then they had gone back to the Privy Council at the time of the appeal. It is the Privy Council that saved them from death. It is the same Privy Council. Now, I'm saying all of this to say that in both instances, not that I'm advocating for the Privy Council or anything, they found that moving to a two-tiered system of the courts, which was pretty much locally theirs, right, was administratively and in the sense of justice inefficient and not in the best interest of the people. And part of the reason for it, Guyana, though it's a big country, has a population of well under 1 million, right? Grenada has a population of about 60,000 or 70 or thereabouts. It's a small country, relatively small, right? Now, the point I'm making, again, is that as we think of what we're hoping for, we need to be mindful of what our resources are, but we also need to bear this in mind. I oftentimes hear people complaining about our court system, and I too have problems with aspect of it. Let me not be cookie crunching anything at all here. I too have problems with aspects of it. But I think we have to be careful that we do not do two things. So undermine our court that we forget that without it, we will lose a critical level of protection. And two, do not put ourselves in a position where we expect more of the court than the resources made available to it can support. And thirdly, that we do not put ourselves in a position either where we do not recognize that we could always benefit from another system and that we have already committed to something else. And that as we talk about the corruption and the other things that you mentioned, that we remember that you should not translate the fact that there's a problem at local level to saying you're going to get a problem at the other level. Remember I told you about Grenada and that they had a problem and it is the Privy Council that saved the people? And that in Guyana, they had their local thing. And when the CCJ came, there were only two. In fact, Guyana, more than any other country with their president at the time, were the ones who lobbied and said to the court, CCJ, start. We want to become a part of you. Sort of thing, because they recognize inherent problems they were having at home. And I'm saying it is all well and good to say we need to learn from our own experiences. But you know what the wise persons do? They learn from the experiences of others, even more than from their own. And I think we have to look at all the things that have happened around us, understand where we're at, and while not trying to debase ourselves, also think of how it is that we can coordinate and do more and do better in our collective best interest. And the Caribbean, quite frankly, has a space in which we can work together. And we have a treaty and other arrangements which are acceptable to us and which we can work within. So what I would want you to help to do, and others of us, is to see how it is that we can do what Silburn was saying earlier, how we can up the ante on public education, how we can up this ante away from political calculus, as I call it, into a point of genuine education in a sense where we try to think nation rather than think party and think all sorts of things, and not get into this habit of trying to allow people to get away with their maladies by allowing them to say, but you did do that and you did do that. The whataboutism not helping us. It hasn't helped us and will never help us. So let us start afresh, say this is where we are, this is how we need to move forward, and this is what you, me, Silburn, Herbert, and everybody else will do to take us to that other level that we need to get to.
Herbert, before we wrap up, go on.
Do you think the better use of time will assist in making our minds up, whether CCJ or Privy Council?
Maybe not, but let me tell you what it will do. And as I say this, it's not just, it's for me, whether we are what the CCJ or the Privy Council, there are still going to be inherent policy construction issues relating to any court that we must consider, right? That's one. And I think one of the things we need to do, and I said it at the beginning, I don't know if you were on then, that we need to get to that point of educating ourselves and our people more about law. And so the time is about education, because sadly, not enough of us understand the law, its implications, or the systems within which we work. Not enough of
No,
us
we
even
don't.
understand the basic nature of our democracy.
We don't.
And that
If
must
you
be a
want to
problem
hide
for us.
something, if you want to hide something from a black man, put it into a book.
Yeah, but since we know that, why don't we then talk more about it in
You know,
organized ways?
you,
If
you
we
know,
believe that to be true.
yeah, you know, Sir Malcolm, do we need to restart the process of the CRC or to amend it, or
Uh,
this whole education process?
all
That's
right,
what I'm.
let me tell you what my view on that is in
Yes.
short is.
Mm,
There is nothing that is ever without value, right?
mm,
And even though the process may not have been perfect and may not have been the way some or even many of us would have wished it to be, I do know that restarting is necessarily the appropriate way to go.
mm,
It may well be that there's need, even at this stage, for further dialogue.
further
And I
down.
think one of the beautiful things that is coming out, quite frankly, with all of the in and outer quote noise that we're hearing, is that people are becoming more sensitized.
Yes.
And
Yes.
some persons who were not even interested in the first instance are probably now more attuned because they're hearing more about it. So the
Yes.
question is, how do we feed off that energy and then get more into the process than we have already got that
Mm.
could help us to go to another and better level? That is what I would say about it.
And then to educate at the same time while this whole thing is happening, isn't it?
And you're speaking to me as a teacher, so if ever
Yes.
you use the word education, you will never get me disagreeing with you at any
Yes.
time of the
Yes.
day.
Yes. Listen,
So,
listen, Sir Cunningham, I want to thank you so much for coming on tonight. We could be here for a long time, but I'm glad that you came on because you have sort of set the stage in a way, and especially with the whole point which I set the show on, which is put it to the people. The people of Jamaica need to be a part of the process. And in your final wrapping up, and you said it out at the start again, and I want to close off it with this: the best way to get the people to be educated. Ideas just said a while ago. The people need to want to learn. That's what Idea of Jamaica just said a while ago. The people need to want to learn. Now, when you have a referendum and then you got to put something to the people, you don't want a situation whereby you got 27% turnout, like for the local government, or 37% turnout for the last general election. What do you say about that? We just want to close off in that.
let me answer in this way.
Yeah, yeah.
We say the people do not want to learn.
Mm,
Let's just accept that as true without debate, right?
yes.
Or is it though that we have not sufficiently packaged what we're teaching and the way in which we're teaching to get persons to learn? I'll give you an example.
Mm,
The Belize constitutional law reform, they're doing some reform process in Belize. At least they're having a series of consultations across Belize, or have been having, in what they call the people's constitutional reform process, or something along that line. I mean, I may have got the name a little wrong, right?
mm,
And I remember I was there because I've done some work there. You know, there are two things that came out of that which it struck me. One is, and I think part of it has to do, frankly, with our own involvement through street law and so on there. Part of it maybe. But you know, one of the critical things that came from the people as part that I'm told that they have been getting as they travel across the length and breadth of Belize, that they're the people coming from the people saying they want teaching about the law and the constitution to be written into the constitution and become a justiciable right. You know, you understand the importance of that?
mm.
They want it to be written in their
Yeah.
constitution that teaching about the law and the constitution is a justiciable right. And as a lawyer, you know, Silver, that if it
Yes.
becomes a justiciable right and it's not provided, you can sue on it.
Mm,
That is important. So that's one thing. The other thing that was critical to me is that they had an engagement down in Independence, and I was there. I spoke, and it was organized in a few days. I was there in Belize to do something else, and this was in a matter of days organized, and I was addressing in a matter of few days, well over 700 persons sitting in an auditorium in something that was organized in a matter of days, in small bellies. What does that say?
The people had
No, it says that they had a
to learn.
process where their leaders, and I can tell you how it happened, their leaders, and it was primarily done through schools. The school leaders reaching out to their community and a lot of those who were there were students, frankly. But the decision was, it is so important to us and we have somebody we need to hear. So I'm saying that we probably need to rethink the ways we do some things. And I'm not saying I'm a master of doing it, I'm not. But there are persons who are better able to determine how is it that we're able to get home ever many people want at stage shows and all sorts of things. We can package these things, twinned with other events and other things, and we do it in a manner which is able to demystify and do things in all. Is there a way? I don't know. But I'm suggesting we need to start thinking a little differently as to how we reach out and how we educate. And sometimes in that process, we need to understand that however complicated the matter is, however complex it is, until we get it in a simplified form, we're losing people. And until we get it to them, and sometimes you have to be careful that you don't try to give it all at once, you give it in bite sizes. So there are things that we can, that is part of why when I started Silburn at the beginning, I said to you that my own thing about, street law and making these things curriculum initiatives in our schools and even in our communities, through our churches and so on, those are the things which will get people excited and get people learning in bite-sized ways. And over time, they have learned without even realizing how much they have learned.
That is the essence of learning. That's the essence of learning, isn't it?
Yes, it is. So I mean, I'm here and I'm saying as well, Silburn, and as I close out, which I suspect, I know we have run well over your time. But as I close out here, I'll say that, I'm thankful for having had this opportunity to speak and to engage with you in this way. And what you're doing, even from the United Kingdom, even as somebody who right now may not be able to serve in our parliament. Right? It's a good thing. And we appreciate, and I say that to say, even though you're not, you're providing an invaluable service. You're providing an invaluable service, and there's several ways in which service can be provided.
You can serve in all areas.
I'm the president of Oturius, Chris, just to let you know.
Renounce the dual citizenship, Mr. Sidian, and then you can represent.
No, the passport is surely also Oturius. There's a different passport to land in Kingston or Montego Bay.
Well, listen, that Sharon just said something. Jamaicans need to be more educated on all constitutional laws of the country. And New York City, Jamaicans need to be more educated on constitutional laws. Totally agree. And
Jamaicans need to show that they need it.
Yes.
Yes, Jamaica is saying that I'm shameless. I don't know if they're saying I am shameless or that I was shameless in how I presented.
No. They're talking about Silburn. They're talking about Silburn.
What's Malcolm? No, listen. Well, I'll take full responsibility for everything.
No. That for me was a joke. Believe me, I didn't take it seriously.
Well, listen, guys. I want to thank you, Sir Malcolm. Thank you so much for coming on tonight. And ladies and gentlemen, Dr. Malcolm is a senior lecturer and deputy dean at the Graduate Studies and Research Faculty of Law at Mona, University of the West Indies. He's a lawyer in Jamaica, the British Virgin Islands, Dominica, St. Lucia, able to practice in all these different countries and the whole wide world. And even he practices in the UK as well.
No, if you give me an arbitration brief, I can come there to do it.
Action now, J.A. Any last word?
Yes, I really want to thank Mr. Malcolm. Yeah, he has, opened my eyes to a lot of things, right, at the level. And I will definitely act upon his recommendation to do some research on the CCJ. But as I said, it can be a contingency, but we really need to address the elephant in the room. And we all know what the elephant is. We can't keep diverting from, you know, our small island with the many challenges that we have, seeking remedy outside. Not really saying that that's what we are doing, but I really appreciate Mr. Malcolm, and that ultimately we can make the step that is needed for the people of Jamaica.
Yeah. Thank you, Mr. Malcolm, and thank you for your support, and thank you for short notice, and thank you for Roger Allen for linking me with you as well. Much appreciated for that. And Herbert, thank you for coming on tonight, and thank you for Miss Super.
Well, since you mentioned Roger, the one thing I'll mention is that he, like I, were sons of the city on the hill, Monroe College.
Monroe College.
From St. Elizabeth.
All right. Yes.
And I'm from York Castle High School. Okay.
Well, I went to Vernon Field on the Canefield.
And actually, know where you from? School?
Well, I went to Catholic school, St. Mary's College. St. Catherine.
Okay, you're St. Catherine. All right.
Yeah. All right. Well, thank you so much, Aldous, and all the best, Mr. Malcolm. Thank you so much. And
okay, thanks, and have a wonderful rest of the evening and church tomorrow. All right.
My lots of portion.
All right. Yeah. Bye. Thanks.
All right.
Again.
Thank you very much.
Bye
bye. Thank you. Well, ladies and gentlemen, I want to thank you so much for joining tonight, and for those who were able to join, and thank you for those on TikTok for those comments as well, for those on Facebook, for those on YouTube as well. Very interesting show, but one of the things that came out very powerfully tonight is about education. Education is key. The topic was put it to the people, put the whole essence of everything to the people, but the people need to be fully informed and fully educated. Do they want to know? I believe, as Dr. Malcolm said, if you give it to them in a strategic way, then yes. Because right now, there's an excitement in the air, an excitement about what's happening with Jamaica, with dual citizenship, whether we like it or not. But now is the time to capitalize on it and educate, assist public education and street law. I'm very interested in this street law, to know about this street law as much as possible. Okay, God bless you. Thank you very much. Idea for Jamaica, Sherry Cunningham, and everyone, all the best. Thank you. Bye-bye. Thank you.